Okay, good morning.
Good morning. Mr. Moya, let me know when you are ready to proceed with the online web video.
Hey, Mr. Chavez, I'm just waiting for it to go live, and it looks like we actually are live right now, so we are good to go.
Oh, good. Okay. So it looks like everybody is here. It needs to be here. We'll make appearances for the record in just a moment. My name is Stephen Chavez. I am the hearing officer for the city of Albuquerque on these land use matters. Today's date is February 24th, 2022, and this is an appeal from the DRB. This is AC-22-1. Mr. Eintema, please make your appearance for the record.
Yes, Mr. Chavez, good morning. I'm Hessel Eintema III. My address is 215 Gold Avenue Southwest, Suite 201, Albuquerque, 87102. I'm a lawyer, and I represent the appellants in this appeal.
Wonderful. Thank you so much. And who is representing the applicants in this case? Mr. Voss?
Good morning. Michael Voss, Senior Planner at Consensus Planning, address 302 8th Street Northwest, Albuquerque, 87102. And I'm representing the applicants along with Dave Hickman is on the line as the architect and Peter Lindborg.
Okay, so this is a closed record review, as you know, Mr. Voss. Do you intend to have anybody testify? Are you going to be making the arguments for the applicant, or do you have counsel? I guess that's my question.
Mr. Lindborg is an attorney. If he wants
Mr. Lindborg is the applicant. He's not an attorney that's representing. I mean, he obviously can represent himself. But for purposes of this matter, are you representing the applicant?
For the purposes of this matter, I am representing the applicant, and Peter Lindborg, who is on the call, is an attorney. He's the brother of the applicant.
Okay, good. Okay, so let me swear you in, Mr. Voss. Thank you. Your hand is raised. Do you affirm to tell the truth, only the truth, under penalty of perjury?
This is Michael Voss. I do.
Wonderful. Thank you so much. Now, who is representing the city of Albuquerque or the DRB? Under these rules, I can allow the city planning staff to make an argument on the record. Mr. Aranda, is that you that's going to be doing this?
Mr. Lujo, good morning. Miss Michaela Renz Whitmore, our your D&D manager, will be representing the city. The DRB. I am here in case any specific interpretive questions from the CEO are asked. So I just wanted to make that clarification. I'm here to provide support however needed.
Okay, thank you. I appreciate it. It's good to see you, Mr. Aranda.
Likewise, you look good.
Okay, so let's swear in everybody who intends to testify who is not an attorney representing an applicant, okay? Who is going to testify? Mr. Aranda, I need you to swear yourself in. Looks like Mr. Lindborg, you're an attorney, so I don't need you to swear yourself in. Mr. Biazar, are you going to be testifying in this case? Mr. Biazar, can you hear me?
Mr. Chavez, yeah, I won't be testifying in this.
Thank you so much. Okay. Anybody else? I don't see the other person that you indicated, Mr. Aranda.
Miss Michaela Renz Whitmore.
I'm here.
Right there. Yeah.
Oh, okay, there you are. Miss Whitmore, let me swear you in. Can you please raise your right hand and let me know when it's raised?
It's raised.
Okay. Do you affirm to tell the truth, only the truth, under penalty of perjury?
I do.
Okay, good. Are there any preliminary matters, Mr. Eintema? And let me preempt at least one preliminary matter. I know you requested that I approve supplementing the record with two supplementations. You had the DRB video, which I don't have a problem with that. I think it should be in the record. And you also had apparently a string of I don't know what those are, so maybe you can clarify, but it looks like they were part of the chat record that was from the DRB hearing from December 3rd. Is that what that was?
Yes, Mr. Chavez, that's my understanding. That page was produced by the city in response to an IPRA request by appellant Karen Baer. And she asked for the chat records, I believe, among other things, and that was what was produced that we think represents the chat records. I had hoped to ask someone from the planning department who could verify and tell us what that was as it was produced by the city.
Okay, I certainly will supplement the record with those two items. Are there any other supplemental requests that you have? I know that when you were presenting before the DRB, you had requested that the record from the 2019 record from the appeal 2016, 20-16, I think, that be in the record, as well as the second appeal that be in the record. Do you still want those in the record?
Yes, and I'd actually like the court case in the record too. Anything that has to do with this case beforehand, I think should be the subject of possible use in review, if any.
I agree. I particularly think that the record should include what occurred in the DRB matters from 2019, the summer of 2019. I can't remember the month, August through September 2019. I think those are relevant. And I think they're relevant because the court, Judge Franchini, who I have great respect for, she specifically required that some analysis be done regarding those records, and so I think I need to have those included into this record. I hate to create duplication because I think it will duplicate some issues, but I do think the records are important to address the remand questions required by the court. So I will get those into the record, Mr. Eintema.
Yes, thank you.
Okay, Mr. Voss, do you have any objections? I will overrule that objection, but certainly you can make a record regarding that.
This is Michael Voss. I don't have any particular objections. Okay,
thank you. Mr. Eintema, go ahead, proceed. I did read the entire record, and I actually I read the transcript of the DRB hearing, and then I reviewed the video, the entire video of the DRB hearing, just to make sure that the transcript was correct. So I'm very familiar with the record. I reviewed all your arguments, and I did ask that the court remand order be included into the record, and it is now in the record. I have reviewed the court's remand instructions in extreme detail. So I think I reviewed her remand order at least 7 or 8 times, probably more than that, but go ahead. Thank you.
Thank you, Mr. Chavez, if it please you. I was going to recite the various issues that we've raised throughout, and there are a number of them that are outstanding from our perspective. But the main part of my presentation today, I hope to go through the transcript and point out from our perspective, the appellant's perspective, why it does not meet the quasi-judicial review requirement. And, you know, there are a number of related legal issues that we think, or following legal issues that we think the DRB did not fairly consider. Some of those issues you've considered in the 2 prior appeals. And those are presented rather by paper, documentary, more than in any other way. And it sounds like I would be just going over something superfluously to do that. But I do think looking from the record that would be helpful in identifying what the problems are on the quasi-judicial hearing issue. The transcript of the December 3rd DRB meeting begins at page 163 of the record. The transcript follows the section in the index identified as, quote, material presented to the Development Review Board, unquote. It would appear from the index that only those materials on pages 82 through 162 may have actually been considered by the DRB before or at the December 3rd meeting. Beginning on page 164 of the record, This is where the meeting starts, and we'll observe that Mr. Rodenbeck, the chair of the DRB, offered off the start of the hearing that the decision would be made, the decision in the hearing would be, the meeting would be done remotely outside, and the hearing, the final signature would be outside of the meeting, and that the chat records would be part of the record. It appears to us that there must have been some prior communication among the DRB members or some coordination to this point, because as far as we can tell, this particular DRB was not to have met or was not even named until December 2nd. That's referring to Mr. Aranda's affidavit on, which is filed at the record at pages 11 and 12.
That wasn't Mr. Aranda's affidavit. I thought that was the previous attorney's.
I'm sorry, Mr. Barella's affidavit. I'm mistaken.
Let me ask you a few questions. Regarding that affidavit, I understand that there is a privilege that was asserted. Have you made an IPRA request regarding that? Is that why the privilege was asserted?
Yes, we made an IPRA request, and some of it was responded to, but there was no assertion of privilege in the response to the IPRA request. And we're still considering going further with that IPRA request because there was a lot that was produced, but not much relating to this case.
Why is the affidavit in the record? I guess I'm a little, I have an idea why it was in the record, but the IPRA issues are certainly part and parcel with your appeal. I don't know if the privilege, the attorney-client privilege in particular, applies to Mr. Varela's, to the issues in the affidavit. I mean, that's for you and the court to determine. I would hope that they would withdraw that privilege because I don't know whether or not he was acting as the attorney for the city rather than acting as the planning director when the privilege was asserted. So I think there's problems with the privilege. But I guess my question though is the privilege, did you make a request regarding how the DRB members were appointed, the new DRB members were appointed, and then the privilege was asserted after that?
I made that request. First, I made the request verbally at the hearing, and Ms. Sanchez declined that, saying that it was privileged. I asked about the process of how this particular DRB was appointed, and also there was the chair made a reference to a background, some background information he had, and I asked about that, but that was not cross-examination on that point against the chair of the DRB was not allowed. The IPRA request I made that I made separately from Ms. Baer was a broader IPRA request and did not just focus on that particular item. From my perspective, I agree that the privilege doesn't, or from my client's perspective too, I agree the privilege does not apply. But what this does, and what the affidavit does indicate, is the irregularity of the appointment process to the DRB, and that contrary to Judge Frank Keating's decision, the planning department was moving members in and out of the DRB. And also the issue about the date of appointment on December 2nd, with the hearing on December 3rd, it's hard to believe that these DRB members actually took a fair look at the materials that had been submitted into the record. So I agree the affidavit I don't know why the city filed it, but I have reasons to be interested in what the affidavit says.
Okay. Do you mind if I ask you questions regarding narrowing these issues? Because I am very familiar with the record, and I'm concerned with the court's remand order. I mean, it's my understanding from reading this record, and certainly people can convince me otherwise, that another remand is necessary, incredibly so, because I don't think that the DRB responded at all to the crux issue that the court found regarding the neighborhood edges. It seems to me that she was very focused, laser focused, and perhaps I should have been previously. That was certainly an error on my part, but the court was laser focused on the timing of the applicants when the planning department deemed the application complete, when they continued the case and they requested additional information from the applicant. The court was very, very concerned with that. She used the words like explicit explanation needs to be put into the record regarding that process and how that process impacts the completion of the application. And I mean, it doesn't, the record doesn't have any evidence, the new record that the court required doesn't have any evidence that the DRB even contemplated that issue. Instead, they made some conclusions that the application was deemed complete, perhaps following what I said, and perhaps inappropriately saying, but they determined that the application was incomplete because it was scheduled for a hearing. Excuse me, let's go off the record for just a second, please.
Yes, I need that too. Thank you. Zooming. Yep. The drill. Yes, I'm back. Sorry.
Okay, my apologies. I have a very large television in my office, and it turned on to a cartoon. I just automatically just turned on, which was very, very strange. And so I had to go turn it off. My apologies.
More fun than this.
Well, I don't watch cartoons, but anyway, my question is, the court was laser focused on that issue, and it's clearly in her remand order. If you look at page 9 of her remand order, the second full paragraph, she says, as discussed at length below, this matter was not in accordance with the law and must be remanded for a quasi-judicial hearing. Because the parties must proceed anew, the court sets out the neighborhood edges issue to assure that the city fully considers, analysis, and explains the interaction of the IDO, the zoning of appellant's property, and the applicable facts. Then she talks a little bit more about that issue on page 11 in the first full paragraph. She says, and this is an order, she says, on remand, the city is directed to explicitly set out the date upon which the developer's application was deemed complete. They did that as this fact was subject to some confusion with further explanation. They didn't do this part. Further explanation as to the finding by the DRB following the July 17th, 2019 meeting that there were comments made by the DRB which needed to be addressed prior to any action on the application, as well as outstanding issues, including grading and drainage plans, infrastructure list, and other comments that necessitated deferring action from the August 14th, 2019 DRB meeting, requiring further supplementation of the application. Now that's a long sentence, but it seems to me that what she's calling for is that the DRB explicitly explain why they deem the application complete when in fact the application appeared to be incomplete, and that's why the meetings were continued. In the new record, the DRB didn't do that at all. So I really believe that a remand is necessary, incredibly so. I mean, I apologize to the parties. to the applicant and certainly to your clients, Mr. Eintema, that I'm saying this. I'm certainly not making anybody happy by doing this, but I do believe that the DRB has to get it right with the remand order and get this issue resolved so that it can be properly reviewed by the city council ultimately. I mean, I appreciate you trying to make your case, and I think you should be allowed to make your case, Mr. Eintema, and then the applicants can respond to that now. But I can't see how I would change that because I didn't find that in the record, that explanation. Go ahead.
Mr. Chavez, by response, all of what you said is correct. From our perspective, that's one set of issues, and even further as to what you've set out. I think reading the court's opinion starting at page 637 and 638 of the record, that's on pages 17 and 18.
Was that appealed, by the way? You said opinion, so did anybody appeal that order?
Judge Franchini's order?
Yes.
No, and I would.
Oh, it's an
say
order.
Probably was not an appealable order under the circumstances.
Okay, so it's not an opinion. I guess that's.
Well, that's okay. Thank you. But the decision, and I think that a further problem beyond the failure of analysis by the DRB is even the constitution of the DRB and then the entire process under which the city conceives and organizes its quasi-judicial hearings for these types of applications. It seems to us, and I can make references in the record if we need to go much further on this, but that the city views this as a business as usual. And I think the court's language in 637 and 638 indicates that there should be an independent type of quasi-judicial hearing review officer or board that is not controlled by the planning department. And
so on that, Mr. Eintema, on that issue, would you agree if I made a recommendation to the city council that this be sent to a independent hearing officer to make a decision?
I don't think it's that, well, that's certainly better than going back to the DRB. But one of the problems from the neighborhood's perspective, and why, one of the reasons why a lot of them are so hot, is that they view the whole IDO system as a betrayal of what their sector plan said and what they had lived with and what they were working with. And so we're at the point that we've got this case, and we're probably bringing artillery into this case that is much bigger than the specific matters discussed in this case. Now, not that they're not interested in this case. Obviously, that's why we're here. But by the way, we'd point out that the whole DRB process is, fraudulent as to quasi-judicial proceedings. There's just no wall between the planning department. They just are going to do whatever they want to do. And there needs to be some type of break on that. So while an independent hearing officer would be appreciated in this case, we don't think that that is just a one-off solution. We think that other neighborhoods are facing this same problem, because the IDO effectively upzoned the entire city and then left it to the planning department to work out the details on particular applications. And I say that it's in this record that the DRB chair could not identify any limitation on density in this zone. So this is a mess from our perspective. And while your statements are entirely correct about a DRB, about another rehearing, we think that a simple remand to this DRB will provoke the same result. And that's why that's why we've identified this as a due process civil rights type issue, because the city seems to be deliberately proceeding without regard for listening to the neighborhoods. And Mr. Chavez, I do not see you on the screen other than at the top. I don't know if there's something going on with the.
No, I can hear you, and I'm on. I haven't changed anything.
So maybe the other parties would have an opinion on these matters.
And I will ask them. I have some more questions. I mean, the court. I mean, your argument regarding R19-035, I think that's the resolution.
035.
You would agree, yes, thank you. You would agree that that resolution is essentially void.
No, Mr. Chavez, I don't. I read that the court said that it was a mistake. Well, there may be testimony brought out. I don't see that R2019-35 has been repealed. And my understanding is, and maybe we can ask Ms. Renz Whitmore about this, is that the latest IDO, 2020 IDO, actually put into effect the limitations of R2019-35. So if the 2018 applies, R35 definitely applies because it hasn't been repealed. And so, I mean, the city's put itself in this terrible straitjacket position. I think that on this record, R2019-35 has to apply in the same way that it applied. You said it applied in the prior hearings because it hasn't been repealed. The judge didn't like it, but she didn't strike it down.
Well, she did say a number of times that this process has to be quasi-judicial. And so, I mean, how do you reconcile the resolution with the process that she required?
Well, one conclusion is that the DRB is not the proper body to hear this under 2019-35, that the city needs to set up a quasi-judicial hearing process for these types of matters.
Okay. Yeah, I mean, I agree with you. I've agreed with you since 2017 on that issue. My concern with the process as it looks now is that the planning staff are essentially required to make a recommendation to the DRB under the 2018 and of course under the 2020 IDOs. It's a requirement. It's not a discretionary thing. In the DRB though, they are essentially making recommendations to themselves. And so that has a problem under the Battershell case, I think.
Mr. Chavez, I don't mean, I'm not really, but yeah, I agree with that completely. And I think the city, I'm sorry for the planning department because the city council's conduct is enough to induce schizophrenia. It's an employees. They're put into an impossible bind. And by the way, the city council expects results. So there you are.
Okay. Go ahead, Mr. Eintema. I'm sorry. I'll try not to interrupt you anymore.
Mr. Chavez, I was going to walk through just the some of the problems, and it sounds like, Mr. Chavez, you are more familiar with the record than I am, even though I was there. I mean, maybe this is superfluous, and you want to take it under advisement. That's fine. That's your discretion. But we think there are a variety of ways in which the quasi-judicial requirement was not satisfied, contrary to state law and the district court's order. I'll just go ahead here. I note that the rules on record 164 and 165, the rules were suspended, and that's fine. But you'd think that there would have been some type of overarching, and this is related to the Open Meetings Act, which of course is important from our perspective as well, that the DRB has to be properly constituted and operating under procedures. And the business of just suspending the rules on everything they've done in the last few years is just not really proper. So I'm going through the record and commenting. I'm providing commentary on why we think these are problems. The record 165 indicates that the DRB does know how to take a vote. I will point out later that the DRB did not take a vote on the actual approval of this site plan. It's arranged for the documents to be signed electronically. And I think that's problematic in the context of open meetings and just proper functioning in a quasi-judicial area. If it's one judge, that's one thing, but the whole thing about things being circulated outside and later is problematic, because at least in the court concept, the judge retains authority over the case until the very last item is dotted and signed off on. In this case, it's not clear whether this site plan has actually been fully approved, because at the end of the record, you'll note that they deferred it, probably improperly also, and set it up to be signed sometime before March 2nd. So it may be out there, and who knows what's going on with the approvals. So this whole process is so I repeat myself. On page 166, Mr. Rodenbeck read a statement that he had written up. Apparently, he said that the 27 IDO involved, quote, increased due process requirements. And that's the staff's position, but we, of course, disagree with that. So on the question of the completeness of the application, on 169 of the record, Mr. Strozer testified that it was taken in on the 17th, and on June 27th, the city asked for another signature, so I guess it wasn't complete. And he says that the latest it could be considered complete was July 11th. However, the DRB, based on materials that appear to be not in the record, as far as I could tell, found that the application was approved on June 18th, based on their internal
deemed complete. It was deemed
complete. Well, it was complete based on their Posse, so-called Posse database, which is not in the record. And I mean, we're just dealing with stuff that we can't evaluate. So let's go on. The next, on page 177 of the record, in an exchange with Ms. Sanchez, counsel for the DRB, she says, "We're not here to discuss legal issues today. DRB is reviewing a site plan under the remand order from the district court." So from our perspective, the legal issues do have to be addressed by the DRB. It is the first instance hearing body. As a quasi-judicial hearing body, for better or worse, it has to make a try on its, within its own authority and jurisdiction to resolve the legal issues. So we think that the city made a fundamental misinterpretation of the court's determination at that juncture. On page 179, testimony of Mr. Fanning, I think I've already pointed out that the city, the neighbors are unhappy, among other reasons, because of the vineyard sector plan was just rolled over, and all of a sudden it's an entirely new ballgame under this IDO. And maybe there's not much legal remedy for that under the powers of a government, of a city council to do it. But that doesn't mean it's easy for the residents, for the property owners to swallow. Next, on page 184, Mr. Rodenbeck makes a determination. He states that it's staff's determination that those properties to the south would not have been protected for lots under the IDO provision as to neighborhood edges. And that, of course, is the key statement from our perspective, because it shows that it's staff that's running, whatever staff is, the planning department is running the show, and not an independent development review board.
But it doesn't address the remand issue specifically.
Yes. On record 185, under questioning from Mr. Regan, there's a discussion about the 10% variation. And that's something that also is very troubling to the neighborhood, that these things go through and there's such a broad level of expansion available with no notice, with just cutting the neighborhood out of the discussion. On page 190 of the record, discussion about staff review and recommendation. My reading of the IDO, is that the planning department is to review and present a recommendation to the DRB or to the decision maker. Probably should be in writing. And in this case, though, Mr. Rodenbeck says that there wouldn't be any staff recommendations, and rather he would give the staff recommendations after the public had spoken. Only then verbally would we get to know the staff recommendations. And what's a little deceptive about that is that later in the hearing, it came out that he had sent the staff comments the staff comments. He had sent the staff comments separately, ex parte, to the developer, who was able to respond to those comments appropriately at the hearing. But of course, that's not, maybe it's not that great a violation because it's only one day, but it's still not the way, it's not the observance of forms that should be forced on the city in this context.
Mr. Einstein, at any time, I know there were a lot of questions regarding why those comments weren't sent to, like Mr. Dan Reagan, when he testified. He was concerned that he didn't receive those comments and that you didn't receive those comments when Mr. Strozer received those comments before the hearing. Did you at any time, and I looked through the record and I couldn't find any request from any of the appellants individually, including Mr. Reagan, requesting that they be that any supplementation go to them as well. Did you make a request to be included in any supplementation of the record?
No, but I was under the understanding that
Right.
in order to do that, you can't just file stuff into the record without, and I'm using a court.
I get that. Yeah.
So I come from that background, but I should say, one of the problems, and we can discuss another of the problems here, is the lack of a proper record before the Development Review Board or whoever is the quasi-judicial decision maker. We think that there should be a written, paginated, chronologically ordered record, and publicly available, so that people have the chance to look at it in some type of a narrative fashion and identify what they want to speak to. This case, and I think all of the DRB cases that I've been involved in, involve the DRB kind of sitting back and having a computer system where they apparently, and if we have testimony today, I'd like to ask about this. They have some computer system that allows them to skim in and skip out and look at what they want to. And most of them take the view, that it's just their particular bailiwick that they're concerned about. So we think the DRB did not have an adequate record to make this decision, and that there should be a record process. On page 190 of the record, of course, Mr. Rodenbach unusually conceded that we'd be allowed cross-examination of him as chair about the planning department recommendations, which is, to say it one way, is not in accordance with quasi-judicial approach.
Let me ask you this question. I know how this process has really muddied the waters for a traditional quasi-judicial body, administrative body. Normally, anybody who testifies to factual issues should be sworn in.
Yes.
That's clear. Neither of the DRB members who offered factual testimony were sworn in. So it seems to me that, because I don't know if, and I couldn't find any case law on this in the entire country. I literally researched the entire country on this issue.
I couldn't either.
There is none. And when I don't find case law on a particular issue, it's because there's a good reason why there isn't cases dealing with that issue, because it's something that shouldn't be done normally. Because the DRB members were unsworn and gave factual testimony, essentially. I mean, I don't know if it can be disputed that what they did was give factual testimony regarding this case. But I don't know. I guess my question is, ultimately, are they immune from being sworn in, from giving this factual testimony because they sit on the DRB? It really muddies the waters of this process. And if so, if they are required to be sworn in, did you waive that right? Because under New Mexico law, a party can waive somebody being sworn in under certain criteria, certain conditions. Is that waived? And, certainly Mr. Lindborg, if he would like to comment on that issue, I'd like to have more legal analysis on that issue, because there's an argument that you waived that. But, there's an argument that you didn't as well. And so I guess this whole process concerns me. So do you have any comment on that, Mr. Eintema?
Well, in terms of a waiver argument, no, we don't. I don't think we waived our objections. It comes on you so fast and so unusually that the DRB is all of a sudden providing testimony, and they've provided testimony without, it's just so out of the blue. We can argue about, there can be an argument, I guess, about whether we waived it, but Ms. Sanchez provided evidence too, I think.
Well, I disagree with that. I mean, she's an attorney. She has a right, an immune right to give advice regarding these issues during the hearing. I don't see how that would.
Well, we'll get to that part of the transcript real quickly here. But yes, Mr. Reagan, one of those comments, I think it would, if it's a requirement that they be requested beforehand, well, I don't think that's really fair or reasonable in the quasi-judicial context. So at page 192 of the record, the DRB comments begin. And Mr. Strozer at 195 responds to the previous emails, comments. At 196, there's some discussion about a street alignment. One new issue that came up through papers presented at this hearing is whether there was going to be a median or not. What was the status of the roadway? And but let me get to that. There was apparently a street alignment. Some street alignment was missing. This is from page 196 of the record. Mr. Strozer addressed that. And then it looks like on 197, there was a new exhibit submitted, which showed the median. And the problem with the median was that it blocks off the appellants who live north of the street, all of a sudden aren't able to cross the street and get into their house on the eastbound. So maybe that has to be done, maybe it doesn't, but it's not something that should be done without consideration and notice and opportunity for people to object.
I thought that Mr. Voss clarified that, and it was in the record, but I don't know if it was Mr. Biazar or another transportation expert, but I thought that was in the record, but it just wasn't found.
He said he thought it was in the record. He said it was in the record, but I haven't seen a reference to that. And I'm not, it's a big record now, but I don't, and maybe it is, but it was news to some of our people.
Okay.
Going through on 199, Mr. Rodenbeck gives the planning comments, which from our perspective, and we think consonant with your discussion before, should be provided prior and in writing, and the parties have an opportunity to respond. And let me say, just on that new median issue, R258 shows where the new median exhibit was submitted after the hearing, and the copies of the new median documents are at R228 through 230. And we're not immediately aware that anything like that is in the record of the case. So it appeared, it was news, as far as we can tell, it was news to us. Well, it was news to us. And if it shouldn't have been news to us, we're not aware of where it was. 204, discussion of the planning comments being sent out before the hearing separately to the applicant. On page 205, Mr. Rodenbeck speaks about, he says that we were, quote, we were provided background on the analysis of the remand recommendations. And I asked him about what does background mean? And Ms. Sanchez didn't let us go any further on that, but that's something that I'd like to explore because I don't think the planning department should be providing non-record background to an independent quasi-judicial hearing body. And I think the judge's decision on page 638 addresses or at least has language that includes that concern. That was where the attorney-client privilege was raised. Not clear to me what the basis of that is, but anyway, this is not the place to litigate attorney-client privilege.
Page 638 of the record, that's the remand order?
Yes.
Okay,
so
I don't have that. I have the remand order, but I don't have it paginated or bait stamped.
Okay, 637 is page 17 of the remand order, and it's the third paragraph at the bottom. The judge cites the Albuquerque Commons case for the statement that the quasi-judicial body should not use nor rely upon any communication reports, staff memoranda, or other materials prepared in connection with a particular case unless made part of the record. And so that's where I think we have a problem with this. On page 205, there's a reference to the database system, and Mr. Rodenbeck on the question of when the application was deemed complete. He's basing it on his determination when it originally came into our office. And he says, and when we processed it, it's my determination that could have been when it was considered accepted. And that's hardly a solid fact-finding analysis for a quasi-judicial hearing. Mr. Chavez, one issue I'd point out that we really did not raise in any significantly in the prior hearings is the question of whether a quasi-judicial hearing is necessary to determine whether the application is complete. And our analysis is that because that application completeness locks in particular rights and privileges for a single property, it constitutes that kind of a point where there has to be notice and an opportunity to be heard and an opportunity to appeal. Because in this case, it was once that determination is made, at least under the IDO, the neighbors, the neighborhood edges issue is sunk. So we think that, although it was not anticipated under the IDO that would be a quasi-judicial decision, particularly or explicitly, we think that the quasi-judicial decision language applies to that determination of completeness of the application. At page 206, Mr. Webb, one of the DRB members, was asked about what was in the record, and he says he's not sure how to explain that. He says, what documents are made available for any meeting or any agenda? That's the normal review process that we go through. And later, I don't have a list. I just have, all the documents that were submitted for record for us to review. And the problem with the record before you is we cannot tell what was before the DRB. There is no paginated record before the DRB. And Mr. Webb's comments also indicate that they were taking this as a business as usual type case, which probably is true from the actual reality of what happened. but we think the judge's order does not contemplate that this will be the same old type of DRB review that has been going on in the past. On page 207, Mr. Rodenbeck states that the 2018 IDO applies without analysis, and he says we applied the 2018 IDO. So that's really a preliminary question. You know, and that's a double-edged sword for us because the 2020 adjustments actually cut out some of the protections of the neighborhood edges. But on balance, and as a matter of law, it seems to me that the pending development application has to be subject to legislative determinations imposed, legislative decisions imposed again while the application is pending. That's the Mandel case, and I think any other rule is going to lead us into chaos. On page 208, Ms. Sanchez spoke, and it seemed to me that it was in a nature of testimony when she said, all of the DRB alternate members representing today were selected because they had not previously reviewed or made a decision on the previous site plan. These members were approved by the planning director with concurrence by the CAO. It seems to me that the affidavit of Mr. Varela is somehow connected with that, and we think that process needs to be transparent to a certain point. I mean, obviously, in a court case, you can't, well, if a judge comes up, judges get replaced, but they're separate out. They're not in the day-to-day machinery of the planning department. So we're not satisfied with this appointment process to the DRB. On 208, one of the issues that's also a burr under the saddles of the neighbors, some of the neighbors, is the question of why on the neighborhood edges issue, their applications were submitted, but there was no determination of completeness to their applications while the developer got to the front of the line. And the testimony is that there was no notice to neighbors that the determination of an application was complete.
But the date of completion doesn't trump like who files first. I mean, the issue is the date of completion is the date that locks which criteria applies, and that's all it does. It's not a race to the courthouse and who applied first. Correct?
Well, it does, because in this case it is a race, because the date of completion, depending on whether it applies, but looking from the city's perspective, the date of completion is the date by which the neighborhood edges protections dissolve or don't exist. So it is a significant date, and all of a sudden the neighbors have lost what they were thinking was their protection under the neighborhood edges provision.
Okay.
On page 209, Mr. Rodenbach identifies that there's not really any density limit in the zone. He provides what appears to be testimony on the batch 1 property's effective date and the batch 2 property's effective date. Those are when he says effective, he's referring to when they were enacted by the city council. What's bothering the neighbors is that they had submitted those, in some cases, a year or more in advance. There was a question on 209 about the chat meetings, and I'm not sure how the chat function fits into a quasi-judicial hearing. That, I think, is problematic, and I don't have all the answers to that, but I think it's an issue. Getting to the end of this, on page 212, a discussion of the batch rezoning and whether there was a written determination to the neighbors of their batch rezonings application being complete or not complete. At 2:13, Mr. Rodenbeck says he needed to read a prepared statement. That's probably, okay, but it is a little unusual that during the hearing, the leading judge would make a statement and read off points of the decision and ask Ms. Sanchez to jump in. Moving towards the end, Mr. Chavez, at 2:15, it wasn't clear what was going on here, and this maybe need a little bit of elaboration. So the rules have been waived for the DRB in this hearing, apparently up front. What that means, I'm not entirely sure, but
That was my question. I don't know what that means either, suspending the rules.
yes. So, but what it means in the context of this hearing. So there's an infrastructure list, and it's not clear to me. There may be requirements in an infrastructure list. I mean, apparently the infrastructure list has come and gone, but they approved. They talked about it and they approved they've all liked the infrastructure list apparently, or they didn't, or they maybe there were some reservations on that. But some of the DRB approvals were delegated, and it looks like there was a delegation towards the delegation towards different authorities. And I'm trying to get my notes here. Which ones were let out? I'm not sure. But Mr. Strozer pops up and says, well, you can only have two delegations made. And I think he's referring to it strikes to me, if you look at page 448 of the record, those are the DRB rules that we insisted be put in. And the top of 448 explains that when an approval regards the signature of DRB members on a plan or plat, at least 3 members or the alternative president of the meeting must sign at the meeting for the agenda item to be conditionally approved and delegated off the agenda. So this discussion on 215 indicates that there were more than 2 authorities on the DRB that were delegating. And I guess their Band-Aid was to have planning pick up the delegation of one of the other parties. And that causes us, maybe that rule doesn't even apply, which is certainly possible as the rules were suspended. On the other hand, it appears that they all know the rules and they look for a kind of a halfway clever workaround on that from our perspective. And let me just say that this type of conduct by the DRB, where the developer leads them through their own rules, is just infuriating to the neighbors. It's like the DRB is just there doing the work for doing the whatever work the developer designates for them. So, and maybe there's nothing illegal about that. Maybe they can delegate the whole thing off the record. We don't think so. But anyway, that's what happened in this case, and we don't, we object. The findings on this is R216, it doesn't appear that there were findings discussed or voted on. At 216, it doesn't appear, or 217, that there was an actual vote. And indeed, a number of items were deferred for later work. So, as I say, until March 2nd, and that's according to, at the start, the DRB decision says that. I want to say on page 16. I'd like to point out one other thing that just got our attention here, got my attention. So page 640 of the record appears to be the public meeting notice, but it actually announces the decision. And if we do have cross-examination today, I'd like to understand how this document was created and where it actually was published, because it shows.
My record only goes up to 622. I don't know what you're referring to.
The record was supplemented and then reissued. When you, according to what we received, you would ask that the case decision, the judge's decision,
I
be
see.
included in the record, which, by the way, we'll discuss, doesn't appear ever to have been considered by the DRB, as best we can tell.
Okay, so everything after 622 is the remand order, is what you're saying?
Okay, but when they paginated it so that 640, and 640 is the public meeting notice.
Okay, because I don't have any of that. I mean, I have the remand order and I have the items that were supplemented, but I don't have the newly issued record. So if you could be a little more clear in what you're describing.
Well, I think it was on page 623 of the record. It would have been page 621 or 622. It's the very last two pages of the record, and the notice. I mean, it's well, I don't know what it is. I have an idea, but it's a notice. It appears to be put in as I mean, in some records I see them put in the notice that they send to the public that they publish. And this is a notice that says there's going to be a hearing, but by the way, the DRB's already approved the decision.
I see that.
So, I get back to the point that there has to be a paginated, chronologically ordered record, particularly on these notices, because I mean, we don't know. And by the way, computer notices come and go. You know, they're fixing the website all the time. And that's just part of the nature of the media. So thank you for suffering through that. We think there are a lot of problems with this case. Perhaps the discussion could be useful. The appellants would like to cross-examine any witnesses for the planning department. We're not waiving any of our legal arguments that appear to be open. And so, thank you.
Thank you. And in a remand, certainly I will preserve all your arguments for later. Okay, thank you. Mr. Voss?
Mr. Chavez, this is Chris, the reporter. I'd like a break. We've been going over an hour.
Has it been that long? Okay, let's take a break. Let's take a break until 10:45. How about that?
That's fine.
No, that's too long. Let's do 10:40, okay?
Got it.
Thank you. Okay, looks like it's about 10:40. Let's get started. Mr. Voss, are you there?
Yes, had to unmute myself. Thank you, Mr. Chavez.
You're welcome. Go ahead, sir.
Thank you, Mr. Chavez, Mr. Hearing Officer. We, just as in brief, I guess, we believe we've followed all of the rules and procedures as they've been laid out. And in the IDO and for the remand instructions for the DRB to hold a quasi-judicial hearing on this case, we, in the hearing, meticulously went through all of the IDO's criteria and believe that this project fully complies with those. Our presentation from the DRB is in record pages 231 to 257 for your information. We did not have ex parte communications with the DRB members. And I think in terms of the arguments about the complete application, we are in agreement with staff that the DRB and the IDO lays out what constitutes a complete application in the 2018 IDO, it was section 64H. It was accepted by staff and scheduled for the hearing, which cannot happen if it was incomplete according to that section.
But the merits of that, I mean, sorry to interrupt you.
No, go
Mr.
ahead.
Boss, again, the applicants have my apologies on these issues. I understand that you folks appear to be working in good faith and that you showed the DRB that the IDO has been met. But the issue is with the DRB, not necessarily with you and your clients. The issue that was remanded, one of the major issues, aside from the quasi-judicial problems, was that the DRB was explicitly, in a quote, explicitly required to do an analysis on why the application was deemed complete in June or even in August, when technically, I mean, this is what she suggested, that technically it looks like the application is incomplete because the DRB didn't hold a merits hearing or didn't conclude the merits hearing. Instead, the DRB pushed it off for another hearing until the applicant submitted, consensus planning submitted more materials, more documentation. Right. And that was the issue that the court really wanted to see analysis on, not from you, from the DRB. And it's, that's the problem with the record.
Thank you, Mr. Chavez. And I think just, in sort of from our position, the DRB deferring action on an item such as they did is typical for the course of any application before that board, or even the planning commission or the hearing examiner, the zoning hearing examiner sometimes needs to defer or continue a hearing in order to get more information in the record in order to make it approvable. From our position, a complete application is not the same thing. It should not be interchangeable with an approvable application. Our application was submitted with all the items that the city puts on their checklist, and whether or not, for instance, we submitted a complete set of drawings, and if the DRB through the hearing process reviews those and determines that, they're not up to snuff, we clearly need to put more work into that and come back for another round of review. And so that's kind of our position there. And then in terms of the argument of the DRB's delegation and signatures after the fact, it's a little weird in its language, I think, but the IDO clearly stipulates that, when a decision is made, conditions can be attached to those decisions. And the DRB, just as well as the Planning Commission, can place conditions of approval, which are outlined in the notice of decision. And we have to follow those. And sort of has been practice with the DRB. They just want us to follow up with staff and get signatures on a plan versus, I think just the same, even if we didn't get signatures, we're held to those conditions, in as long as the approval remains valid, subject to the expiration in the IDO. Regarding the neighborhood edges, I think we covered that in our presentation to the DRB based on the date of completeness, and don't feel the need to really elaborate a whole lot further on that. for you. And I think with that, I mean, we're really here. We can answer any questions that you have. We believe that we did our part to present the necessary evidence for approval of the project to the DRB, and from our position, do believe that the DRB, fulfilled what the remand instructions really needed them to do for this project.
Mr. Voss, regarding the exhibit that Mr. Eintema has raised that wasn't in the record, well, he believes it wasn't in the record, and apparently you clarified to the DRB that you believed it was in the record, and the next day after the hearing, or within a few days after the hearing, you supplemented the record to include that it was a design pictorial of the street, the Alameda and the other street, showing the median. Was that already in the record? I thought it was, but my memory isn't as good for 2 years back.
Yeah, and Mr. Hearing Officer, thanks for that question. I certainly don't know the record as well as you probably do, or even Mr. Eintema from 2019. So I can't confirm if that was in the record for sure. During the hearing, we did show that on the screen for the participants before we then followed up to give the document officially into the record the day after the hearing. But I think from a roadway design perspective, I mean, the city of Albuquerque does roadway projects, and they have sort of classifications for roads. Alameda, in front of this property, is a major collector roadway, and they sort of have standard details and designs that, whether or not the developer ends up building them, which the city asks and requires developers to complete frontage improvements when we go through these processes. But beyond that, these designs are more fully vetted through different processes, and there's standards, including medians and things like that, that I think are outside of the purview of the IDO and zoning, and the process for which the hearing process and the neighborhood involvement is for.
I have a question for you, and it might be more appropriate for Mr. Lindberg, but I'll ask, and Mr. Lindberg, if you need to jump in, please help answer. I raised the issue regarding a remand. I mean, it's clear to me that a remand is necessary, and honestly, I dislike remands terribly, especially with a process that's been gone around so many times already. It pains me to even say the word in this case. But I do believe it's necessary to deal with the judge's order. Would you be agreeable, and you can say, I don't know, would you be agreeable to a hearing officer, an independent hearing officer being appointed by the city council or whoever does that, not by me? It wouldn't be me, to deal with that process, just to protect the integrity of a quasi-judicial hearing, because the court already ordered that. Mr. Lindberg?
Yeah, thank you, Mr. Chavez. We've got a problem with your suggestion, and I understand where it's coming from. Lawyer to lawyer, I understand where it's coming from, but what's going on in this process writ small right now is essentially an attempt by the appellants here to rewrite city policy, and this just isn't the forum for that. I mean, we could make it up as we're going along, but I don't think either of us have the power, nor do I think the DRB has the power to sit there and say, well, in this case, we're going to ignore city ordinance. I understand, and Mr. Eintema made it clear today, that a whole lot of what's driving this process right now from the appellant side is not this project. You've heard very little about this project this morning and very little about the project the last two times. It's about the policy. Well, that's not this forum. And if I could make a couple of other points, and then unless you ask me something else, I promise I'll shut up.
No, please.
Mr. Voss had it absolutely right in terms of the issue of the completeness of the application. I'm certain that we can't conflate the idea of a completed application versus a plan that gets modified through the hearing process. I mean, the analogy for us legal types would be the complaint is the complaint, and when you get to trial, the pleadings are fixed, or actually long before you get to trial, the pleadings are fixed. But that doesn't mean you can't talk about anything outside of the four corners of the complaint at trial. And decisions get made on those bases. That doesn't make the application, your ticket into the courthouse, any less complete. The other point I want to make is we have to remember, and I understand from the appellant's point of view what's going on here, but we have to remember that this is a quasi-judicial process, and a lot of the things the appellants are asking for here, you wouldn't even get in a judicial process. So, they don't get to remake the perfect world here. And those are the only comments that I would have.
Thank you, Mr. Lindberg. So back to my question, Mr. Lindberg. So I understand the problems that appointing a hearing officer for one particular matter would raise. I only suggest that because I've done that before in the Los Chavez case, the one that the court cited, where I went through the appellate process to the Court of Appeals, went back down to district court. I made the argument to the court, look, Judge, every one of those commissioners are biased now because they've had communications, whatever. But the court said, well, I'll consider that. Take it back to the commission, the political body. So I went back to the commission and I argued to the commission, every one of you are biased at this point because you folks have done things that creates that bias. So I would ask that you appoint an independent hearing officer to make your decision. The zoning ordinance didn't allow for that, didn't even contemplate that process, but they all voted to allow that process. Went back to the court approved it. There was some negotiation about a hearing officer. And then I think Mr. John Myers was the hearing officer in that case. And it got resolved very quickly after that. That's why I proposed that. Now, I don't know what the city council would do with that, honestly. I just don't know. But I mean, it can work if everybody agrees to it.
I don't disagree with you, Mr. Chavez. I just think it's not our decision to make.
Yeah, I certainly, and you don't have to agree to it. So no problem. Thank you so much.
Thank you.
Mr. Voss, is there anything else you would like to add for the record?
Mr. Chavez, no, at this point, I don't think there is.
Okay. Now, Mr. Eintema has the ability to cross-examine you. So, Mr. Eintema, do you have cross-examination for Mr. Voss?
Yes, for Mr. Voss. Mr. Voss, do you know who prepared the, oh, I'm sorry. Mr. Voss, have you worked for the city?
Mr. Hearing Officer and Mr. Eintema, yes, I have worked for the city.
Were you involved with the preparation of the IDO?
Mr. Chavez and Mr. Eintema, I was not directly involved in the preparation of the IDO. I reviewed elements of it and provided comments to the staff that did. And once it was adopted, helped preparing application forms for implementation of it.
Okay. And that was when you were as a city employee or outside?
When I was a city employee.
Okay. And when did you leave city employment?
I left the city employment in January, February 2019.
Okay. Did you have any other discussions with the planning department about this application after the remand order?
Mr. Chavez, Mr. Eintema, after the remand order, no, we did not have any discussions about the application. I mean, other than the meetings that you were involved in with Ms. Sanchez about procedural issues.
Okay. Thank you. I don't have any other questions of Mr. Voss. Mr. Chavez, will there be a planning department representative available for cross-examination?
I was just going to ask if the planning department wants, they have that discretion. They don't have to participate, but under the rules that were adopted for this process in 2004, we've always given the planning department the opportunity to comment. And certainly if somebody comments, then you can cross-examine. So I guess, Ms. Whitmore, is that you?
That would maybe be me. I do not have any questions at this time.
Okay, do you have any comments? Anything you would like to add to the record?
I do. Is it my turn?
It is your turn. Did I swear you in already?
You did.
Okay, thank you. Go ahead.
All right. So a few things that I'd like to add from the planning department perspective. So on the completeness issue, so the June 18th, 2019 is the date that the planning department accepted, processed, and placed the site plan application on the DRB agenda for the July 17th hearing via the city's case tracking database. So that process is an administrative function.
It's ministerial, essentially.
It's exactly. And once it's complete in the way that it was described by the applicant in terms of are the checklists there, are the right sheets there, that administrative function is not looking to evaluate how good the application is. They're just looking to see, do we have everything we need to begin the review process to evaluate the case. So just want to call your attention to the IDO section 66H1 that talks about the completeness of the application. It's one that contains all information and application materials required by the IDO, the DPM, and any administrative checklist for that type of development in sufficient detail and readability to later evaluate the application for compliance with applicable review standards. So that iterative process begins after the application is deemed complete, and that review process continues until the application is good enough for the DRB to actually approve. So based on the IDO section 110B, that's the element that says once it is accepted as complete, meaning staff can begin its evaluation of how good the application is. That's what locks in the standards and criteria that were in effect at that time. The IDO in 16A talks about the official zoning map as the latest version approved or amended by the city council and maintained in electronic form. And I just want to say explicitly that on June 18th, 2019, the official zoning map showed the abutting property to the south as MXT, which is why it was not eligible for the neighborhood edge provisions because the protected lots are only in the RA, R1, RMC, and RT zone districts per 59B1. So that's on completeness. Any questions there?
Yeah, I mean, why didn't the DRB deal with that issue? That was a specific major remand issue for the court, and the DRB is supposed to analyze that issue.
So
not me. I mean, we can't defer to me to analyze that issue for the DRB at this point, because I believe that the court's order was very specific about that, and she specifically required that the DRB analyze that issue. And it's so there's no analysis of it in the record, except now there is.
Well, it may be that you're not satisfied with the analysis, but the findings 1 through 6 of the notice of decision do go into responding to the court remand. So it's up to you to determine whether that's sufficient or not, but they did address it. And from staff's perspective, it's very cut and dried. Application was deemed complete. That's the date. 110B says that's what locks it in.
Yeah.
Pretty straightforward from staff's perspective.
Right, but again, the court, I understand that. Yes, I see the analysis. That analysis was done in 2019, by the way. I get that. But the court said that's not enough. The court wanted to include the analysis of why the application was deemed complete when it was also deferred.
Right, and again,
let me finish.
Oh, sorry.
Issue. That's okay. That was the issue that the court wanted analysis on, specifically that issue, and there's just not any.
I'll say that I thought findings 1 through 6 did talk about the analysis. I think the piece that was missing was the differentiation between deeming it complete, i.e. we have everything we need to start the review of how good it is, versus the iterative process of hearings and what happens.
Right. No, one of the things that I don't want to do is look at the trees without looking at the forest, but the court wanted that. And so I just feel like I need to send it back to the DRB to really provide that analysis. And I hate to do that. I mean, I won't go into that, but yes, go ahead.
Let me talk a little bit about kind of the getting to the quasi-judicial kind of elements of the case. So let me back up just a little bit and say the IDO requires site plans with more than 50 multifamily dwelling units to be reviewed and decided by the Development Review Board. That's per 5G1C 1B and 66G. So backing up a little bit, the DRB was first created in 1982 with the express purpose of streamlining case review by bringing together technical staff for that specialized review of projects in a forum where staff and the applicant can meet to discuss together all at the same time, and the public can be there to ask questions and provide input. So the DRB reviews cases for compliance with the IDO and the Development Process Manual, or DPM. And the IDO establishes the decision criteria for that site plan DRB in 66G. Very quickly summarized, does the site plan meet the provisions of the IDO, the DPM, other city regs? Is sufficient infrastructure provided? And does it mitigate significant adverse impacts on the surrounding area to the maximum extent practicable, which I just want to say is a defined term in the IDO. So section 7.1 definition says maximum extent practicable means no feasible or prudent alternative exists as determined by the relevant decision-making body after the applicant has taken all steps to comply with the standards or regulations and to minimize potential harmful or adverse impacts. So talking about this quasi-judicial hearing, I want to point out that in table 611 of the 2018 IDO, a site plan DRB decision only requires a public meeting, not a public hearing. That's the IDO.
That distinction is form over function. And I think I even said that in 2017. Now the court's saying it. So that's not relevant.
Well, and I think it comes back to the point of here's what the IDO is requiring, and the court is asking for something outside of what the IDO requires. And I do feel staff's being put in a position where we can't meet both.
Right.
And so what we've tried to do is say, okay, the decision criteria is not discretionary. It's what it is in the IDO. And
But
we can provide.
You just described one of the many discretionary issues that the DRB has to confront. I mean, how could you argue that My apologies, Ms. Whitmore. I know the position you're in, and I honestly, I feel terrible for the position that all the parties are in, including the city staff. But you do exercise discretion that impacts rights of property. That there's no way around that, and it can't. The resolution that adopted that is essentially, I know Mr. Eintema says it can't be ignored, but the court saying you have to ignore it if you're going to do the right thing here. So I would hope that it's going to be voided soon by the city council. It may not, but I would hope that it is, because I don't believe it can be applied to the DRB acting in a discretionary manner. I do believe that the DRB acts in a discretionary manner on a bunch of issues. I see the nuts and bolts of the site plan. There's very little discretion to exercise, but there are other discretionary issues that it acts upon, and that's the problem. And I see the tugging that you folks are under, and it's terrible.
And I'll just say, I do think city council is the right body to give us some recourse on that either DRB is and needs to be holding quasi-judicial hearings, which is not what the IDO actually says, or it's not. And that matter is not really, the DRB itself can't decide that. So what we've done in this case, we held the quasi-judicial hearing, and as to the best we could as staff. And I think all the points that have been brought up, that DRB members are acting both as judges and as witnesses, is a problem that we handled as best we could. And I think what the distinction that I would draw is that we tried to hold the process as quasi-judicial as best we can. But I'm still saying that the decision that was made was constrained by the decision criteria in the IDO. So I don't believe that that decision was discretionary. I think they didn't have discretion in the decision whether or not they can have to hold quasi-judicial hearings is one for city council to decide. But I would just say that R19-150 enactment 35 made it clear that council did not want DRB to be a discretionary body. I hear you say that's in conflict with what the court remand was, which is our issue.
That was one of my findings before, and the court chastised me for that. And I don't like to be chastised by the court, but
neither do we.
But the problem is that it's a problem now, and it's up front, and it's this applicant that it's in front of, unfortunately, and right. It's the neighbors that are confronted by it, and it needs to get resolved one way or the other. It's going to get resolved one way or the other. I honestly don't know how, but I do believe that this remand is one of the ways it's going to get resolved, because I want to make sure that every detail of the court's order, not an opinion, not recommendation, of the court's order gets resolved, so that the city council can resolve the bigger issues later, if there are bigger issues for them to resolve.
Agreed. The other thing that I'd like to introduce is just the idea that if there is no way to approve a site plan that is not deciding on the rights and entitlements, which you're saying is always true, then there also can't be staff decisions made on site plans. So this, going down that road means that no site plan could be approved outside of a quasi-judicial hearing by a quasi-judicial body.
I understand what you're saying in theory. I disagree with that. I think there is a way to do that, and it can work.
That's what we'd like to maintain is how the DRB can still provide the benefits of bringing together staff to have the discussion in front of the public on a site plan where the body itself doesn't have the discretion to go outside of the rules, but are just deciding, is the application good enough to get an approval. Once it's good enough to get an approval, meaning it meets all of the standards in the IDO and the DPM, meets the decision criteria, it gets the approval. I think there's a benefit to the public of that process, which is why there's a middle ground between staff approving it at their desks in cycle, right? It goes to each staff member to be approved, and having a discussion in front of the Development Review Board. The IDO sends things that are bigger and potentially that have more impact on the surrounding properties to the Development Review Board, precisely to give that window and voice to the neighbors into those kinds of decisions. That was different from the straight up zoning code, which had a lot more things that went straight to building permit that weren't, site plan reviews per se, they were just building permit approvals. So I'd say that the IDO is actually trying to give more of a window into the process and voice to the neighbors in development decisions in terms of site plans, and perhaps problematically. I think just to respond to some of the concerns about the staffing of this DRB, I will say again, the DRB is a staff board. Staff in the planning department is fully assigned to other things. And so it was a bit of a scramble for the planning department to pull together staff that hadn't been involved in the review previously and who could still serve in the capacity of DRB members and chair. That was predominantly and because of turnover and other things, vacant positions, that was hard to pull together until the last minute. So just, I think that describes.
I saw that valiant attempt. So
yes. And quickly about the comments that were sent. So again, a little bit of weirdness between Jay Rodenbeck in his capacity as a staff planner to the DRB. As a matter of course, emails, comments prior to the hearing to the applicant. In this case, those, while that may constitute ex parte communication, those comments were discussed at the hearing and made part of the record. During the hearing, the public did have the opportunity to ask questions and provide input. In general, the fact that the hearing was conducted via Zoom was following guidance provided by Attorney General Hector Balderas regarding the Open Meetings Act. The chair, Jay Rodenbeck, in his capacity as chair, did give instructions at the beginning of the meeting that participants needed to raise their hands to be recognized and sworn in if they wanted to speak. So even though the chat was enabled in the Zoom hearing, anything in the chat was not to be considered by the DRB as sworn testimony because people weren't sworn in via the chat. So the chat document is automatically produced by Zoom when you record a hearing, and that's that chat record that you have. So the chats that were that little text file of chats was actually produced by Zoom when the hearing was recorded.
I did not see any request to speak in the hearing based on the chat. The chat,
correct.
The chat requests were just essentially just adding comment to the record.
Correct.
Nobody requested to speak. I saw that. Yeah.
Correct. So I'll just finish up by saying I support that the findings in the notice of decision support DRB's decision as not fraudulent, arbitrary, or capricious, and that the decision was supported by substantial evidence. The DRB applied the requirements of the IDO accurately, particularly 1B, requiring the DRB to consider standards and regulations in effect at the time that the application was deemed complete on June 18th. And with that, I stand for questions.
Mr. Eintema, cross-examination?
Yes. Ms. Renz-Whitmore, was a copy of the district remand order provided to the DRB members before the hearing?
I do not know. I believe so, but I would need to check just to make sure. That's something
do you believe? What do you believe what do you base your belief on?
I know that the staff was given direction from city legal about the remand order, but I don't know whether the actual remand order was distributed at that time. I think it was with the case materials, but I would need to confirm that.
What was the background that was provided to the DRB that Mr.
It
Rodenbeck spoke about?
wasn't substantive about the case. It was really talking about what the remand order was asking for, and that there was going to be a remand hearing, and the thoughts that the planning department had at the time about how we would need to constitute a different DRB with different staff members who hadn't been involved in the case before.
And why did the planning department consider that anybody who'd been in the case before could not be on the DRB?
If you know, Miss Renz Whitmore.
Sure, my understanding is that the remands order talk about impartiality as part of the quasi-judicial hearing process seemed to indicate that having different members involved in the same way that Mr. Chavez, you talked about in that other case, that having heard it previously, the DRB members probably couldn't or had a bias and needed to have different members look at it with fresh eyes.
Ms. Renz Whitmore, looking at the record at page 184, Mr. Rodenbeck states in the middle of the page, it's staff's determination that those properties to the south would not have been protected for lots for, and then referring to the IDO for the 2018 IDO. To your knowledge, did staff make a determination about that application of the neighborhood edges? I believe you've spoken that the staff did make a determination about that, but
The findings in the notice of decision again support that the staff looked at when the application was received, processed, and put into the Posse system. That date determined the completeness date, and staff then looked at when what the zoning was on that date and whether the batch rezonings had become effective on that date. And as you know, they were made effective after.
my question goes to the issue of when staff made a determination, if they did, and how that was communicated to the DRB. Can you provide any insight on that?
I don't have insight into that.
Was there a staff memo or any documentation that set out the staff's position addressed to the DRB in this matter?
Not that I'm aware of.
Can you give us some insight into the appointment process? Because some of the notices that we received for the hearing indicated that you yourself were going to be the DRB chair for the meeting. And then apparently you were withdrawn on December 2nd, if I understand that. The day, well, I don't know, it's not clear what happened. Can you walk through what happened with the DRB membership?
I do not have the full picture into what happened with DRB membership. I can speak from my own experience, which was that I was asked to be DRB chair and was in the process of deciding whether to stay with the city as an employee, and just basically said, I don't think I'm the right person to do it in the meantime. And they made a different decision about the chair.
And that was the extent of your involvement in the—
That was the extent of my involvement.
Okay. From the planning department perspective, what is the status of R2019-035 today?
As you mentioned, it is incorporated into the later versions and today's version of the IDO.
So it lives. Is that fair to say?
It is fair to say.
Okay. What is the Planning Posse database system. Very briefly, I don't mean to go on with this, but
Yeah.
this is a new term for me, and I've been around these things for a while.
Sometimes called Posse, sometimes called Posse Mesa. This is a case tracking database software that the city uses to receive the application. Note, it assigns the project number, the case number, follows that application through to the notice of decision. Key documents are uploaded into that case tracking software.
And does it, so it does take in notes? Does it take in records of meetings and memoranda and things like that?
It can, staff has to, it's not automatic, staff has to upload things, and it is not considered the complete record of the case. It eventually should have the full record of the case, but at any particular point, I'm not sure if we consider the case tracking software as the official record as the case is being reviewed.
And let me ask it this way, but I don't see any evidence that the Posse database system is in this record other than being mentioned. Do you see that is the Posse database information in this system, in this record?
The record is the record, and eventually the record should move into the Posse Mesa. It's an envelope, it's a repository. It's not, it doesn't in and of itself have different information inside it.
Mr. Einstein, are you referring to the metadata from the Posse database?
Well, I'm not.
Metadata that could be tracked regarding what's included in the Posse system, but I think the Posse system is the house for the data. Is that correct, Ms. Whitmore?
That's correct.
Okay.
I can't place my hand on it right now, but there are a few places in the record where specific reference is made to the Posse database system, and that decisions were made based off the Posse database system. For example, on page 2 of the city staff memo, that's R2 in the record, and then Mr. The chair, Mr. Rodenbeck, a few times, referred to the database record for justification for his decisions. And I don't see, or explanation for what he was deciding. I don't see anything like that in this record that can be identified as the database that the decision was being based on. And for example, the testimony in the case is that the application was submitted on June 17th, and then that there was a requirement because it apparently wasn't complete, even though it had been accepted as complete, and that the applicant responded by July 11th. But Mr. Rodenbeck, reading apparently from some database that's not in the record, determined that the actual date of completion, of deemed completion, was June 18th, which is a date that hasn't appeared in any of these hearings before. So my question is, is there a separate repository? And I guess there is a separate repository. You've answered that, I think. And why isn't it in the record?
So it sounds like what you're asking, let me just confirm that I'm understanding, is whether there could be a record provided out of Posse Mesa showing the date that the case was entered into the system and put on the agenda, which gives you the June 18th date. Is that your question?
Yes.
Whether there could be a record provided from Posse Mesa itself that shows that date.
Well, that's one question, yes.
And I think it could, as far as I know, as far as my understanding of Posse Mesa.
That would be the metadata from the program.
That would be the metadata, okay. Correct.
What I'm, at the court level in judicial proceedings, we have a docket, which is a running tally with dates and who submits. So if you look at the record, you can look at a page of it and you can reference it. Would it be possible for the city to, well, first let me ask, does the city have any chronologically ordered, paginated record of what happened in this case?
Not that I'm aware of.
Okay. Okay, well, I guess that's the end of that discussion then. Is an application complete without an infrastructure list?
Yes, the infrastructure list is not a requirement of the application. It's a requirement of the approval.
Okay. Did this DRB for this application, the ultimate DRB, did it have any meetings other than the December 3rd, 2021 Zoom meeting?
The only meeting that I'm aware of was with city legal staff, again, talking about, that was the background information that DRB was going to need to hold another hearing, that the planning department was going to find other staff members to serve as the DRB, but no substantive issue about the case was discussed. It was the process discussion. That's the
Okay.
only meeting that I'm aware of.
Were you at the meeting?
I was at the meeting.
How many people were at the meeting?
I don't know exactly. My memory was around 6, and it was led by Ms. Sanchez.
And did it include the members DRB members who actually voted, who actually heard this matter?
I don't believe Jay was there because he wasn't determined to be chair until later. So I'm not exactly sure. It was the folks who had been identified at that moment.
And how would he have gotten the background information if he wasn't at the meeting?
So when he
How would
was,
Mr. Rodenbach have gotten the background information?
Sure.
if he didn't?
I believe he spoke with Ms. Sanchez when he was identified to be the chair. She provided that information to him.
Okay. And was he appointed, am I correct that he was appointed December 2nd?
Yes.
You know what time of the day he was appointed and what time that happened?
I do not know. I believe he was told the day before, and then it was made official through the memo on the 2nd.
Would you agree with me that being appointed one day and then serving as the decision maker the next day is not sufficient time to come up to speed on a matter like this?
It's unusual, but clearly he did do a review and felt comfortable making the decision at the hearing.
Is the membership of the DRB moved around a lot?
No, usually the DRB is delegated and decided. This case in particular, because of the remand instructions, was definitely different.
Has there ever been a case of membership at the DRB handled like this case?
Not to my knowledge.
Okay. Okay, thank you. I don't have any other questions.
Thank you.
Thank you, Ms. Franz Whitmore. Mr. Eintema, closing arguments?
Yes, Mr. Chavez and thank you for your patience and courtesy in hearing this out. The one thing I wanted to go over on the remand issue, because I thought a little bit about that. I think a direct remand, which I understand to be under the LUHO's authority under the IDO, is problematic in this case, because if you just do a straight remand, if it's just a straight remand back to the DRB, we're going to get lost in the same loop, because I don't know how the DRB really can be constituted at this point. And it's kind of like the case you described, but I think it's different in that the case you described, I believe, was a one-off situation. And this is a systematic problem. That doesn't mean it doesn't apply to this case, and it doesn't mean that we don't have valid objections to this application on its merits, particularly as to the neighborhood edges. So we disagree with Mr. Lindbergh's argument that this is entirely about quote fixing the system or something like that. But that is part. In the end, that's what has to happen, we think, for this to come out. A direct remand to the DRB gets us into that loop. I think otherwise, a direct remand to a hearing officer is problematic, because that's not really authorized in the IDO. And I think that particularly on an ad hoc basis, that is not the problem. Maybe the precedent could be set and set into the ordinance, but that's not the way the ordinance is set up. It might be that a hearing officer like the ZHE, or, I don't want to repeat the obvious here, but the EPC handled these types of applications before, and they didn't have this quasi-judicial hearing problem. So, I mean, this is a self-inflicted problem by the city council. So those are my comments. Thank you very much.
What would you have me do with this case at this point? I mean,
Mr. Chavez, I think the correct result from our end is that the case is reversed, and that's it, period. And that's it. If the city council hears it or doesn't hear it, and perhaps you want to make recommendations about what type of a structure would be appropriate for this type of decision making. But I think we're at a dead end with the planning department and the DRB as a place to decide this application.
Thank you. Okay, thank you, folks. I will have something out within the next 2 weeks. And with regard to a hearing officer, I would think it would have to be a stipulation by all sides for a hearing officer to work in this matter. And obviously, there's not stipulation on all sides. That's certainly everybody's right. So that would be off the table. So, okay, great. I will see what I can do and get back to everybody as quickly as I can. Thank you so much. Let's go off the record.